All right, good afternoon, everyone. I am showing at 12 o'clock, so we're going to go ahead and get started. Good afternoon. My name is Haley, and thank you so much for joining the first installment of the Special Asset Summer School series. This is our 2025 Summer Asset School edition. I always semi-jokingly, but very seriously say that it's not summer until we're doing the Special Asset Summer School series. And this class today is going to be led by Lily Faulconer and Michael Fields, and they're going to be covering topics relevant to agricultural borrowers and problem loans. I'm Haley Cook, Marketing Coordinator of Events and Proposals here at Warden Smith. I'm going to be your moderator this afternoon. Lily, can everyone see my screen now?
Yes.
Okay, great. Thank you. Sorry about that. If you have any issues with Zoom video or sound quality during the presentation, please reach out via the Zoom chat feature. Once again, I should appear as Haley Cook, and I'll try and troubleshoot with you. This webinar is being recorded, and I will send out a recording tomorrow. One thing I did want to point out to you all is that these webinars live on our website. So if you go to Warden Smith, our homepage, have it right here, and you click webinars, you're going to be able to see all of our past webinars so that these are all last year's, so that you can share with your colleagues or your friends, or you can reference this as needed. So that is a great resource for everybody. Our speakers today are happy to take questions during this webinar. If you have a question, please type it into the Q&A box and it will be addressed either during the presentation or at the conclusion of the presentation, just depending on how relevant the question is, and it's up to Lily and Michael. As I mentioned, our speakers today are Lily and Michael, both creditors' rights attorneys in our Greenville office, and I'm going to turn it over to Lily.
Thank you, Haley. Welcome, everyone. We're really excited to have you here with us today. As Haley said, my name is Lily Faulconer. I practice here in the firm's Greenville, North Carolina office with my colleague, Michael Fields. And we're going to be talking to you today about agricultural borrowers and problem loans. So we're going to kick it off with bare bones basics and go over a couple of common types of agricultural loan documents. These are basically just common types of loan documents, right? These are typical of what you see in many lending relationships. So we're talking about promissory notes, security agreements, UCC-1 financing statement, deeds of trust, and vehicle or trailer titles if there is vehicle collateral involved. Michael is going to kick us off discussing some common problems with these documents. So I'll turn it over to Michael.
Thank you, Lily. And again, welcome everyone. Thank you for joining us this afternoon. Each industry group that you as special assets officers deal with presents its own unique challenges, and the agricultural industry is no different. Based on my experience, what you're dealing with is someone who is perhaps good at what they do, and perhaps even has an education, but they don't have lawyers on retainer to prepare loan documents. They don't have a legal team to review contracts. And so what that means oftentimes is these loans, once you take them over, they kind of are messy sometimes. Perhaps not as much with regard to the bank's documents, but with regard to other creditor relationships that they may have. For example, they may have creditor relationships with crop input suppliers and other vendors. Some of those vendors may be unsecured and likely are unsecured trade creditors. Others may have taken crop liens or equipment liens. and their documentation may be a little less than organized. So it's with that background that Lily and I wanted to address some of the documentation issues that you may find yourself with in the ag sector. So one of I guess the first issue here is what are common problems with loan documents for the agricultural customers I'm inheriting? And this can be approached more in two different time frames. One is maybe when you're doing a credit review before it's actually turned over to the special assets department. You're taking a look at what documents that we have at our disposal and any other opposing creditor type documents. And then secondly, maybe once it's already in-house at special assets, and maybe you've gone on for some period of time, they have in the special assets department, maybe some changes have occurred with that customer that requires some reaction on our part. So with that background, let me kind of I guess further by way of example say that many farmers have more than one operating entity. They may have no operating entity at all, but if they do, it's quite possible that they have more than one operating entity. That is one entity, more than one entity that produces the crops. In addition to that, many farmers may own equipment in one or more of these operating entities, or they may own equipment in separate equipment holding companies. So they may have multiple entities. And the problem that sometimes creates for special assets officers and those of us who represent special assets officers is that the loan documents don't accurately reflect the current situation. That is, the loan documents, the credit documents may not cover all the operating entities. We may not have all the operating entities on the hook, or we may not have gotten all the operating entities to pledge the crops and crop insurance and government program payments as collateral. Similarly, we may not have all of the equipment holding company entities on our security agreements or on our UCCs. So that presents obviously issues for us, as well as issues relative to other creditors which may have their documentation in order. So what can and I guess before I go on to kind of what can we do about that is the obvious effect of that, potential adverse effect of that is reduced collectability. So what are some of the strategies, easy strategies that special assets officers can undertake once one of these agricultural loans winds up on their desk? First, you can ask the customer questions. For example, what business entities do you own? Which of those entities produces or owns the crops? Who owns the equipment? And most of the time you'll get a fairly straight answer. You may have to do further digging, but you may get a relatively straight answer. But if you want to do more digging, then ask the customer to see things such as personal federal income tax returns. and you would normally do that anyway in your job or have those already available. But you would look at those to try to ascertain, well, what other legal entities is that farmer individual receiving, K-1s on. You can also ask to see the business's federal income tax returns. One thing that you may or may not do regularly is ask for current and prior year FSA 578 forms. And so what is a FSA 578 form? That is a form that is generated by the U.S. Department of Agriculture, specifically the Farm Service Agency, on an annual basis after the farmer has certified to the FSA about that farmer's acreage and crop mix for that particular year. Now, why would the farmer voluntarily provide that information to the FSA? Well, number one, it's typically required for insurance purposes. The crop insurance companies will want to see that as part of the proof as to who owns the crops and that the crops are planted. But secondly, they will do that for government program payment purposes. By their certifications to the federal government, that will help in turn identify the, universe of crops that they own that might, under certain conditions, be eligible for disaster payment money, for example, or other government program payments. So bottom line is you can ask the farmer for current and prior years FSA Form 578s, and you can therefore determine who owns the crops, or at least has owned the crops in prior years. Also, you can do some internet due diligence. There are a couple of places that we typically look when we're trying to determine, who is our customer, and are there other entities or individuals that may be related to this customer as it relates to their farming operation. One place we look is the Secretary of State website. You can look in a couple of places there. One, you can look at the corporations and LLCs division to kind of see what entities are affiliated with that individual. Secondly, you can go to the UCC portion of the website. You can type in the name of the individual or the names of the entities, and oftentimes those UCCs will list additional entities on those same UCCs. So again, you can take the customer at its word, but perhaps better is to check behind him or her as well. Another place you can go is the EWG subsidy database. There is a publicly available database, and it can be found at farm.ewg.org. And that is a culmination of work done by others that downloads information off the publicly available government websites regarding government program payments. And you can determine through that website by checking on the recipient locations tab. That's the recipient locations tab for other businesses or individuals that use that same address as that customer. So again, another way to kind of check behind yourself and the customer as far as what other potential entities are out there. And then once you have done all that due diligence, and if you ascertain that you need to perhaps clean up the documentation to some extent, you certainly can do so at that point through a modification or forbearance, and get those additional individuals and entities to sign on the hook to become liable for the debt, as well as to pledge collateral. And I realize that some of these loans and relationships with customers kind of go on for some period of time within the special assets department. And so I would recommend that this process that I just mentioned of having conversations with the customer, and then asking for documentation, and then doing your own due diligence online, I recommend that be done at least annually. And then that way you can hopefully try to, in addition to your other efforts, it's additional effort to try to stay on top and catch any changes that are made sooner rather than later. So those are my, I guess, comments at the moment regarding the loan documents, and I'll now turn it over to Lily.
Thanks, Michael. So now we're going to dive into some problems specific to UCCs. So let's say you know who your obligors are, and you have filed a financing statement that you believe includes all of those parties, but you realize, or you are informed either by your borrower's attorney or another creditor, that your UCC is incomplete or incorrect. And what I mean by that is perhaps the individual borrower's name is not complete, or is not the name that is on their driver's license. In North Carolina, an individual's name on a filed UCC must match the name on their driver's license. So it's very important to verify that your UCC includes the name of any individual obligor as it appears on their driver's license. It's also possible that the name was misspelled. So perhaps a business entity name is incorrect because it's misspelled or only partially included. Those are going to have the consequence of rendering your UCC invalid, and therefore the adverse effect of that is that you are subsequently unperfected. So you thought you were perfected and now you're not, which puts you in a different position than you had hoped and you thought that you would be. Easy ways to avoid that are kind of going through the exercises that Michael just described, right? Doing the diligence on the business entity names, checking that you're using the legal names of any business entities as on file with the Secretary of State, making sure that you have copies of valid and current driver's licenses. As Michael said, these relationships can span a number of years, so you want to make sure that your documentation remains current, and that includes updated driver's licenses. You don't want a copy of an expired driver's license to be the copy that you're relying on, just in case there is any name change that you're not aware of. So let's say that you have checked all of those boxes and your UCC is valid, it's correct, it has complete names, correct names, and your UCC covers crops, but your name is not on the crop proceeds checks. A potential adverse effect of failure to include your name, so the bank's name on the crop proceeds checks, is that you don't receive those proceeds even though you are entitled to them. To avoid that outcome, before extending credit or continuing to extend credit or modifying a loan, or as a condition of modification, want to make sure that you are aware of the parties to whom your borrower is selling crops. So want to have a list of all entities, potential purchasers of those crops so that you can send statutory notice to all of those crop buyers. That notice is governed by federal law. So it's in Title VII of the United States Code, and that section 1631 spells out what must be included in those notices. And what's typically required is the name and address of the secured party, the name and address of the obligor, the social security number or tax identification number of the obligor, and then a description of the farm products or the crops that are subject to the security interest. And so that includes, if you have the information, the amount of the crops, maybe all crops, and maybe a certain amount of acres or pounds or production based. Also need to include the crop year and the name of the counties where the farm products are produced or located. So you have to include all of that notice, all that information on your notice under the federal statute. So important, again, to review the information if you have a multi-year relationship every crop year. Relationships in the industry may change. Your borrower may find new buyers, and you want to make sure that you are sending notice to any new buyers that emerge throughout the course of your lending relationship with this borrower. Finally, what happens if you have a valid UCC that covers crops of a North Carolina farmer and you are providing financing for the crop year, but the borrower had a prior bank that it worked with, and that bank has a prior UCC, but they're not providing an operating line of credit for the crop year. So, borrowers can form new lending relationships. They can, as Michael said, have multiple lending relationships all at once. And so it's really important to understand where you fall in that priority, especially in North Carolina, where if you have not addressed priority issues related to the crop year, the bank who has that prior UCC on crops can assert a priority lien on the crop proceeds as a result of previously providing an operating line for the production of the crops. This is a result of something called a production money priority. It does not exist in all states, but in North Carolina, lenders who provide production money financing have priority. And so if you do not provide notice to the bank with the prior operating line, they will have priority over you, even though you are providing financing for the current crop year. Not all states require notice be provided, but still recognize production money priority. And not all states recognize it at all. So in South Carolina and Virginia, that is not something that is recognized. But here in North Carolina, that is something to be aware of when you are extending credit, perhaps to a new borrower, or more often in the special assets situation, trying to manage a relationship that has come in and perhaps navigate out of a problematic situation through some financing for the current crop year. Michael, anything else you'd like to add on that?
No, Lily, I think you covered that well.
I'll turn it back over to you.
Okay. Thank you, Lily. So the next part of the webinar deals with farmland leases. Some farmers, as you know, own their own land and farm that land. Others, however, may lease farmland from third parties. The third parties may be family members or maybe others in the community, but they are an individual or entity different from the individual or entity that is producing the crops. Those leases, as you know, can take many forms. They can be just 1 year leases. They can be multi-year leases. They can be written or they can be oral, that is on a handshake. So they come in all shapes and sizes, and there oftentimes is not anything in the public record that would cue you as a special assets officer in to which of the leases are third-party leases and who are the third-party landlords. So one of the first things that we recommend when you get a new agricultural account in to special assets is in addition to assessing the loan documents and UCCs, as we've talked about, is also give some consideration to the landlords and the farmland and whether there are any leases. And particularly, it's important as to whether or not the leases are paid for that farm year or not. Many leases are paid up front for that crop year, whether it be in December or January or February. Other leases may be paid at the end of the crop year, October, November, December. So it depends. It depends on what the farmer can get the landlord to agree to, and it depends, on the custom in the community. So it varies. If the land rent is paid current when you acquire the account, then great. But often some or all of the land rent may not be paid. And it's in that scenario that I wanted just to mention here that each landlord for unpaid rent has a lien on the crops that are grown on that landlord's land. In addition, the landlord under North Carolina law has a lien on insurance proceeds for those crops that are grown on that landlord's land. Again, to the extent of any unpaid rent for that crop year. And furthermore, this North Carolina statute indicates that the landlord's lien on crops grown on that landlord's land and for the insurance proceeds have priority over all other liens. So even if the landlord has not filed anything of record, and even if the bank prior or at the time of the loan transaction or prior filed a UCC, that landlord's lien jumps ahead of that prior filed UCC to the extent of unpaid rent for that crop year. Not much you can do about it. Once you get it, you're kind of stuck with that fact situation. And even, for subsequent years, it might be difficult from a practical standpoint for you to do anything about it because the landlord may if we make it too difficult on the landlord may decide to rent that land to someone else. So most of the times it's not a huge deal, but we have seen some situations, certainly, and even currently, where that has been an issue. So just be aware that there are some potential landlord liens out there, and that you maybe can do some due diligence to find out if it's a problem or not. Lily, that's really all I had on the farmland leases.
Thanks, Michael. Before I jump into general strategies that you all can leverage and utilize in your agricultural relationships, I want to address a question that we received on UCC filings. So it's pretty common for creditors to file UCCs that are not specific to a crop year. So by that, I mean, all crops, and that UCC is filed, let's say in 2022, we're now in 2025. It is still active, current, and perfecting the lien of a creditor in crops. However, when you are sending a notice to a buyer, how do you go about that when you don't have a year on your UCC? Well, if you have a lien on all crops, and you want to provide these notices annually to buyers, you can reference the crop years for which you have not been paid, the crop year, the current crop year. And then, of course, you can also include a copy, and you should include a copy of your security documents, your filed UCC, which shows the buyer that you do have a perfected security interest. So you don't have to change the language of your UCC to be more narrow or more specific, or file a UCC every year in order to successfully send a notice to buyers of your interest in crops for a particular year. And with that, I'll jump into kind of general workout strategies that you all can leverage or should be thinking about when you are working with these problem loans. Most of this applies outside of the agricultural context as well, but as Michael mentioned, there are some things that are unique to the industry that you'll just want to be mindful of as you work with these customers. And so typically, as Michael mentioned, these workouts take the form of loan modification agreements, forbearance agreements. And so what are key terms that you want to include in those kinds of agreements? First and foremost, you want to have the obligors acknowledge the debt and the amount of the debt. That prevents the obligors from later challenging their obligation or challenging the amount of their obligation. You want to clearly set forth in any modification agreement what is owed, and have the borrower and any other obligors confirm that amount. One thing you may want to consider, and many of you do require as part of a modification, is some kind of partial payment due upon execution of any modification or forbearance agreement. And also, of course, important in these documents is a clearly established repayment plan. We've talked a lot today about documentation defects. This is the time to cure those defects. So if you have found issues with any of your loan documents, now you can address them. And so as we've talked about, what are you looking for? What are you, what may you need to address in this document? The legal name of the entity or the individual. For example, easy one with individuals, I go by Lily. My legal name is Lillian. If Lily's on your documents, it's not going to match my driver's license, and it's not going to be my legal name. And so that's not going to cut it for you. So want to make sure that you're using the legal name of your individual borrower and the legal name of any business borrower or guarantor. You also want to make sure that whoever is signing on behalf of these entities has the authority to do so. So you want to verify that you have authorized signers for each entity. You can verify that information by looking at records on the Secretary of State's website, but most effectively through entity documents that you can request from your obligors. And so those would be operating agreements or bylaws that would set forth who has the authority to sign documents. Sometimes agricultural entities don't keep great records. They may not have updated operating agreement, updated bylaws. They may not really have them at all. But you want to have some sort of confirmation or verification that the individuals who are signing your documents have the authority and the ability to do so. Additionally, you want to make sure, as Michael mentioned earlier, that if there is additional collateral or additional entities who own collateral, such as equipment, that you have contemplated that and included either that equipment or those entities, or perhaps both, in your documentation. You also want to make sure when you are describing the collateral that the description in your security agreement is consistent with what is in your UCC. So if for any reason you include a serial number for a piece of equipment on your security agreement and in your UCC, you want to make sure that those numbers match. Oftentimes we see where maybe a number, just one number in the full serial number was missed or mistyped, and that can create an issue with perfection in that piece of equipment. And so, again, want to be sure that the name on the UCC is the legal name of your business, is its complete name, and matches any individual's name on their driver's license. And finally, as Michael discussed earlier, you also want to make sure that the entity who is pledging this collateral is the entity that actually owns the collateral. If there are additional entities who own equipment or other collateral, as Michael mentioned, you may want to bring them on as additional obligors. Additionally, if for some reason you just started out with the business being on the hook for the debt, it could be an appropriate time to have the principals of the business join as obligors. If they have other entities, as Michael mentioned, you may also want to include those. In addition to equipment collateral that other entities may own, we talked about leased farmland, but many farmers also own farmland. And so do you have real property collateral? And if so, who has pledged what interest in that collateral, and have your obligors acquired additional real property collateral during the course of your relationship? If so, it may be appropriate at a modification or forbearance stage to have that collateral, that real property collateral, pledged as part of your modification or your forbearance. When you are approaching the addition of real property collateral, you want to think and investigate who all owns that property. It may be your customer, your borrower, together with others. And so we'll need to think about who needs to sign the document and how much percentage interest you will have in property based on whether your borrower owns it individually or with others. Additionally, if your borrower owns land that perhaps crosses county borders or is located in multiple counties, you want to make sure that you're recording your deed of trust in each county where your real property collateral is located. Recording it in County A, as you all know, will not do you any good in County B. You need to record it in County A and County B for that to be effective. Additionally, an important term of any workout document that you all are negotiating with your borrowers and obligors are releases. So as a condition of a workout, it's important to include a release of claims against the lender. And so that, of course, is just a provision that you would put in, and it is typical in many of your modification or forbearance agreements. If you are accommodating the borrower, you can condition, that accommodation on a release of claims against you, and that's claims. You can include a limited release or a larger, broader release, which is typically what we see. But certainly want to include release language in any kind of forbearance or modification documentation. Michael, anything else you want to add about considerations for documents?
No, but there is another question in the Q&A that I will try to answer when you're done.
Yeah, go ahead.
Okay. So the question is, how does PACA impact a lien on agricultural products? Very good question. So for those, most of you probably are familiar, but some of you probably are not. And so what is PACA? PACA is the Perishable Agricultural Commodities Act. It's a federal statute that has been around for a long time. And that typically comes into play with things like sweet potatoes or cabbage or other produce that is sold by a produce farmer to a packing company, for example. And in that scenario, PACA gives well, let me first say there are a lot of requirements and exceptions and nuances, but the general rule is that the producer of the crops who sells them to the packer, let's say, or the middleman, has a lien, a constructive trust lien on that produce. And that lien is superior to a first priority security interest that a bank may have been given in crops or inventory or accounts receivable from that middleman, from that packer. So PACA very well could impact adversely a lien on agricultural products. And so one of the questions that would need to be asked if you're dealing, if your customer is a middleman, a packer, sweet potato packer, or someone like that, is who are your suppliers, who are your producers that you buy from, and are you current on those payments? And it's been a while since I've had a real sophisticated PACA case, but they come along every 5 to 10 years, and I oftentimes will have to refresh myself about the various rules and nuances and all that. So if you get one of those, if you have a customer that is in that position, then we can certainly roll up our sleeves and help you analyze whether or not your collateral is subject to any prior PACA claims. So a good question on that. That's all I got, Lily.
Thanks, Michael. It looks like we've answered all of the questions. And so give you all a second if you have any additional questions to shoot them in the Q&A box. But otherwise, we'll give you back just a little bit of your lunch hour.
Did anybody have any questions for Lily or Michael? Lily and Michael, let's see. Anything else you'd like to add?
No, I'm good. Thank you, everyone, for joining us. And Haley, do you have the information on the next
I do.
webinar? Okay.
Yeah, thank you guys so much for joining us, and thank you, Michael and Lily, for a great presentation. Please save the date regarding our next installment of the Special Asset Summer School Series, and that is going to be Tuesday, July 22nd. So tomorrow, I'm going to send out an email with these slides, with this recording, and also look out for a link to RSVP for that next one if you haven't done it already. The next one will be hosted by Norman Leonard and Thomas Wolf on special topics in collections, foreclosures, and workouts. So thank you so much. We're grateful for your participation, and hopefully you can utilize what you've gained today. That's going to end today's webinar. Thanks, everybody.